Hello, my name is Jason Roth. I'm an attorney with the law firm of Roth, Davies in Overland Park, Kansas. Today I want to talk to you about the unfortunate non-economic damage cap in Kansas on cases involving personal injury. Many of you might have heard of caps on damages or ceilings, or tort reform is one of the common terms that's used. A lot of people don't realize how these things are actually applied in lawsuits. So today I want to talk to you specifically about Kansas Statute 60-19A02. This is the statute that provides a limitation on the non-economic damages that a person can recover in a claim involving personal injury. I'll give you an example. Let's say there was a case where somebody was injured in a wreck and the person was 35 years old, had two kids, age 8 and 5, was a decent wage earner, and he coached all of his kids' sports teams. He coached his daughter's soccer team, his daughter's softball team. He coached his son's basketball team and his son's lacrosse team. Those are the things that he really enjoyed doing with his time outside of work and household obligations. What he really enjoyed was spending time with his kids and coaching them. Well, if he was in a wreck in Kansas and the at-fault person acknowledged that the wreck was their fault, the person that caused the wreck, or the company that caused the wreck, they would be responsible for his medical bills. So there's no limitation on the medical bills, both past and future. They'd also be responsible for any lost wages that he incurred, whether it be past lost wages or future lost wages. However, the limitation where it applies is for the things that really matter. That's what the legislature has called caps on pain and suffering. Really what that is, it's a cap on non-economic damages for loss of enjoyment of life, loss of activities, loss of ability to do the activities of daily living or take care of yourself. Under my example, if the gentleman that was in the wreck that had the two kids, if he was paralyzed from the neck down, he would be able to recover his medical bills, he'd be able to recover his lost wages. But if the wreck happened in June of 2018, he would be limited to $325,000 in non-economic damages. In other words, the Kansas cap, as provided by this statute, would limit his recovery for non-economic damages. Some people think that's patently unfair because what that really does is limit the recovery for the things that really matter in life. If you're in a wreck, nobody asks you, how much are your medical bills? If you're in a wreck, people don't say, well, how much are your lost wages? Well, the reason is because those aren't the things that really matter. What matters is the time that you're able to spend with your friends and family and doing the activities that you enjoy. Unfortunately, due to the cap imposed by the Kansas statute, you're limited in your recovery. If you have any questions regarding personal injury in Kansas, car wrecks, or a question how the statute on non-economic damages applies, please don't hesitate to contact me, 913-451-9500. Thank you.